This is how you get the affirmative defense of waiver stricken from the record in a trust accounting lawsuit in the state of Florida. I'm attorney Blake Moore, a trust and estate attorney at PTM Trust and Estate Law, and we are talking about trust accounting lawsuits in the state of Florida. Now, every single year, trustees are required to account to the beneficiaries of their trusts, but a beneficiary is allowed to waive that accounting. And that waiver is found in subsection 2 of Florida Statute 736.0813. And it starts, a qualified beneficiary may waive the trustee's duty to account. So waivers are a valid thing, which is why when a plaintiff, a beneficiary, sues a trustee for an accounting, you will often see the trustee plead a defense, an affirmative defense of waiver, saying, no, I didn't have to provide that accounting. You waived that right. So I didn't have to, which means that your lawsuit is not valid. I didn't have to account to you. I'm not liable for any damages, and I'm not liable to account. But if you keep reading in subsection 2, what you find is that it states waivers and withdrawals of prior waivers under this subsection must be in writing. Now that's important. We care about it needing to be in writing because that makes all trust accounting waivers written documents. And written documents get a special rule in the Florida Rules of Civil Procedure. If you take a look at Rule 1.130, it states that all bonds, notes, bills of exchange, contracts, accounts, or documents, that's written documents, on which an action may be brought or defense made, so it includes affirmative defenses, or a copy thereof, or a copy of the portions thereof material to the pleadings, must be incorporated in or attached to the pleading. So you can't just allege that there is a waiver. No. You have to prove it. There's a written document. There's always a written document with a waiver by statute. There will always be a written document if there's a waiver, which means if you plead waiver, you are pleading an affirmative defense that requires the attachment of a written document. And if you don't provide that written document, then your affirmative defense can and should be stricken from the record. You are opening yourself up to that plaintiff filing a motion to strike and removing that affirmative defense completely from the record. I'm Blake Moore, Trust and Estate Attorney at PTM Trust and Estate Law. Like this video and subscribe if you want more information on trust and estates in Florida.